a bit colder. It was intentional to be cool because of how warm it was outside, but we'll cut that down. Welcome. For those of you who I haven't had the chance to say hello to, my name is Wes Rist. I'm the Director of Education and Research here at the American Society of International Law. We're very pleased you could join us this evening for what looks to be a very interesting event. For those of you who are unfamiliar with ASIL, we are a 108-year-old professional membership association. We were started by then Secretary of State Elihu Root, who in 1906 looked around and said, there's this international law stuff. It's becoming important. We should have some people who know about that. And since then, we have fulfilled ASIL's mission of public education and outreach on international law. We are a nonprofit, non-advocacy, non-partisan group. We take sides. We are a convening organization. We are very proud to be kind of a neutral territory where we can bring people together to discuss the really important and very difficult and sometimes very controversial issues that address international law. Of course, as international law has grown, our membership has grown in the areas that they're interested in. So we have a number of interest groups that focus on substantive areas. Everything from international economic law to international environmental law, international human rights, law of the sea, international law and technology. We also have some focused on some demographics, so we have some focused on geographic areas, as well as a women in international law interest group, who one of our co-chairs is here today, and a new professionals interest group, who one of our co-chairs is here today. In finding out more about the society, we have membership brochures downstairs, so please feel free to take one of those. And by all means, feel free to ask me any questions after the event if you've got any more. I'm pleased that you're able to join us for today's discussion, as we've been doing a couple of different events on a variety of topics where different areas of international law are touching upon each other. And today's event promises to be one of those where there's a discussion of things that you would normally not expect to find in one area of international law where it's touching on others, and that should be an interesting component of today's discussion. Our moderator, Ben McGrady, is the director of the Initiative on Trade, Investment, and Health at the O'Neill Institute for National and Global Health Law at Georgetown University Law Center. I apologize for reading, but that was a long collection of elements there. So he's published on the on trade and public health, the WTO, tobacco, alcohol, and diet by Cambridge University Press, and a World Health Organization report entitled Confronting the Tobacco Epidemic in New Era of Trade and Investment Liberalization. I'm going to leave it to Ben to introduce the rest of our speakers today, but we're very pleased again that you could join us. I did want to mention, just as a point of pride, Emily McKenzie here, who is one of our international law fellows, organized this entire event. So we're very pleased that she was able to put this all together as part of her international law fellowship. So without any further ado, Ben, I'll turn it over to you.
And thanks also very much to Emily for organising the event and for the invitation to moderate what I think promises to be a very exciting and interesting panel. And also special thanks to the American Society of International Law for the invitation to be here. Just before I hand over to our speakers, I want to say a few words about investment treaty arbitration, international investment law, for those of you who might not be familiar with the basics. I know that many of you in the audience will be, but some of you may be coming at this issue with a background in international human rights law or a background in public international law. So I'll just say a few words that will hopefully lead into Ryan's presentation. So in very basic terms, international investment agreements are found in the form of bilateral investment treaties, also in investment chapters in free trade agreements or preferential trade agreements. They provide protection for foreign investors, protection against expropriation, nationalisation, also indirect expropriation or government intervention that has the same effect as expropriation. They also provide protection or a standard of fair and equitable treatment, the international minimum standard of treatment, sometimes as found in customary international law, sometimes a standard of treatment above and beyond that. Protection against non-discrimination, protection against violations of other commitments made to foreign investors, such as contractual commitments. It is most common to see these agreements in a bilateral form, but sometimes they're multilateral through regional trade agreements. And more often than not, they are standing to bring claim directly against the state through investor-state dispute settlement. And in so doing, they take disputes between the foreign investor and the host state out of reach of the domestic courts, the core function, arguably, of international investment agreements. And disputes through this system are settled through arbitration, primarily through ICSID and UNCITRAL, which no doubt we'll hear more about this evening. So having given that very basic introduction, we are here this evening to speak about the intersection of international investment law and individual and collective rights. I'm going to do my best to keep our speakers to time and then provoke them with a series of questions. And then I will hand over to the audience for questions, discussion. The idea is that each speaker will speak for 10 minutes, have some response to the other speakers' comments. Then I'll provoke each of our speakers in a friendly and polite manner with some questions and hand over to the audience. So without further ado, I will hand over to Ryan Malski, who's an associate at Three Crowns, a practitioner in the field, and he's worked in a number of different law firms over years in arbitration, with a particular focus on investment treaty arbitration. So thank you, Ryan.
Okay, thanks very much, Ben, and thank you, Wes, and also thanks, Emily, for organizing. It's my pleasure and privilege to be speaking with you and with this very distinguished panel today. So in order to try to get a handle on this very broad topic, I thought I might use my time allotment here to focus in on a very specific set of cases and a specific issue within those. And I'm referring to claims that Philip Morris Company, tobacco producer and manufacturer of cigarettes, has brought against the countries Australia and Uruguay in response to those countries' enactment of plain packaging legislation. These countries have decided that it's in the public interest and for the health and safety of their people to try to reduce the appeal of cigarettes, and this way they decided to basically require that all cigarettes be packaged in brown cardboard boxes, no distinguishing characteristics except that the name of the brand is on the cigarette pack. And so Philip Morris has responded by claiming expropriation, or more specifically indirect expropriation of their property rights in these countries, and they've brought claims under the relevant bilateral investment treaties that Ben just talked about. So that's just sort of a setup of the topic. A few years ago, one of the leading scholars in investment treaty arbitration sort of predicted that this type of issue would be coming to the fore. He said the single most important development in state practice, speaking in the context of investment law, has become the issue of indirect expropriation. So in decades past, the main problem between states and investors tended to revolve around outright, very obvious direct expropriation of foreigners' assets, right? You can imagine, and it still happens in certain countries around the world, where the government nationalizes a certain industry. They sometimes send in the troops, and they physically take possession of an oil company or the like. And so the treaty provides for protections against expropriation of that nature. But those types of expropriations have dwindled and been replaced by a more nuanced kind of expropriation. This concept that a state, short of taking title to certain property, might take measures which have the same effect of taking title. And so this gets us into a tricky area. And this is precisely where we might wonder whether Uruguay and Australia have committed this kind of a breach of the treaty. So again, just kind of setting this up, the cigarette companies are kind of shifting the conversation from talking about health issues to talking about investment issues, right? And as Don Draper says, if you don't like what people are saying about you, change the conversation. So some people are wary of the move by Philip Morris to take this action under the purported guise of an investment protection. So I've already kind of laid out the position of the state and the investor. The critic is going to say that due to the specter of foreign companies prevailing in frivolous challenges to national regulations for public health, we should purge investor-state dispute settlement from treaties. In other words, the reaction against the prospect that cigarette manufacturers might be able to dictate what kinds of laws a state can pass, we should just get rid of this dispute settlement mechanism altogether. And I want to examine whether, whether that's necessary or whether investor-state dispute settlement might actually provide a robust enough set of substantive and procedural laws that appropriately carve out a space for states to take these kinds of measures which implicate, so clearly a public health interest. So I asked myself, well, what does the law say about this? You go to the statute of the International Court of Justice, and it kind of lays out in Article 38 what are the sources of law that the investment tribunal can apply. We can look to treaties, customary international law, general principles of the laws of nations, judicial decisions such as prior arbitral awards, and the writing of jurists or scholars. So I just kind of want to walk through the analysis of what principles might aid the state in this case. We look at the treaty. It provides on expropriation or measures having the same effect have to be under due process of law with a public purpose on a non-discriminatory basis and with compensation. This is sort of the classic formulation of an expropriation clause, which just sort of sticks in a provision about indirect expropriation without really unpacking the nuances of that particular type of claim. The Vienna Convention on the Law of Treaties guides us in our interpretation of that clause. So we just look at the ordinary meaning. The act, expropriation, the act of taking of privately owned property by a government to be used for the benefit of the public. That doesn't quite seem to capture what's happening in the Philip Morris cases. It's not that the government is taking the Marlboro logos and using them in their own state-owned tobacco company to promote their products. It sort of seems like instead of taking something to confer a benefit on the state, they're just acting to eliminate or reduce a harm. To me, that strikes me as something a little bit different. The VCLT also guides us that we can look to help under customary international law. And indeed, there's a distinction in customary international law between compensable expropriation and non-compensable regulation to achieve a valid public policy goal. This might be the hook for Uruguay and Australia to hang their hat on and what the tribunal will look to in evaluating these claims. When we look at the decisions of arbitral tribunals, we see that they're unpacking the idea of indirect expropriation with these principles of a sole effects doctrine, legitimate expectations, and direct benefit to the state. Let's see how these provisions might help the states. The sole effects doctrine says that to evaluate whether an indirect expropriation has occurred, just look at the effects of the measure, and that will decide the matter. So if there's a really extreme effect, then the issue is decided. I sort of think that the tribunals, probably working very late at night, decided, let's just apply the sole effects doctrine and get out of here and go get some tacos. Other tribunals have applied a little bit more nuanced analysis. They find that effects on the investor are necessary but not sufficient in the analysis. You should look at the state's purpose behind the measures. Even this article by Ben Mostafa, who says that he's an advocate of sole effects doctrine, he finds one exception, this Latin provision, which I won't try to pronounce, but it's this concept that one person shouldn't use their property in a way that damages another. So he gives the example, no expropriation where a state regulates or even bans an investor's chemical that represents a serious threat to human health. And Rudolph Dolzer comes up with a similar exception and endorses that. In the Methanex case, they have analyzed the concept of legitimate expectations in an evaluation of a claim of indirect expropriation. And they said Methanex entered a political economy in which it was widely known, if not notorious, because of regulations for health and environment. There's arguably a similar situation with respect to Philip Morris in Australia and Uruguay, where the harms of smoking have been known for decades. So they couldn't have had a legitimate expectation that these types of regulations wouldn't be enacted. Other tribunals also look to see if there was a direct benefit conferred upon the state in enacting these regulations. You know, in a case where a state expropriates an oil company, then they get to get the profits from the oil revenues. In this case, as I mentioned earlier, the states aren't getting necessarily the benefit. Okay. I'll just wrap up by mentioning that there are a couple principles which help to kind of define and distinguish these measures as not being indirect expropriation, but rather a legitimate exercise of the state's police powers to regulate matters in the public interest. And there are another number of cases on point here dealing with health issues which take this tack and find that they would tend to support the proposition that the states, Uruguay and Australia, would not have to pay compensation for these measures as an exercise of their police power. I'm just going to fly through here because I'm running out of time. States have increasingly been writing their treaties to actually flesh out this idea of indirect expropriation that we saw that was not developed in the treaties with Australia and Uruguay, kind of unpacking that, saying sole effects doctrine is rejected, and specifying and enumerating non-compensable regulatory measures, including those that are for public health. So this kind of state practice, although it shows that these clauses and language were missing from the treaties at issue, which is a point against Australia and Uruguay, still tend to help us see that perhaps norms of customary international law are crystallizing. Can do that as a source of law. Basically, just in conclusion to wrap up, I'm going over time. Investor-state dispute settlement does provide a legitimate forum to decide legal questions at the intersection of states' rights and investors' rights on the international plane. In these cases, there is a reasonable foundation of substantive law for at least a narrow holding by an ISDS tribunal for sovereigns to enact plain packaging legislation for tobacco products in the interest of public health. And even if the countries lose in these cases, that will give them incentive to clarify the terms of their treaties going forward and help develop the international rule of law. I should also just in closing say that nothing that I've said here represents the views of Three Crowns LLP. I should have said that at the beginning. This is simply an exercise to try to kind of explore and understand what are the issues at stake here. But my analysis is based on very limited information about Philip Morris cases, and obviously I can't offer a definitive legal opinion about that case, those cases. So be happy to take any questions, and sorry I'm over time.
Thanks very much, Ryan.
Okay.
We will come back to you for questions shortly. In the interim, I'll hand over to Susan Aronson. We're very lucky to have Susan here with us. She's a research professor at George Washington University's Elliott School of International Affairs, and has written, published, spoken quite widely about the intersection of international trade, human rights, and some of the issues that are very much on our agenda today. So thanks very much, Susan. Over to you.
Emily, thank you so much for inviting me. It's nice to meet you all. Please excuse my voice, although it's not that different from how I usually sound in local wars. But, okay, so here's basically my take on this. The German government established a bilateral investment treaty with Pakistan in the interest of improving the rule of law for German investors. Ironically, I would argue that history has shown that maybe investment agreements at the regional level, bilateral level, etc., may not improve the rule of law. So let me give you a sense as to how I've come to that conclusion. Okay, so let's talk about what we want here, right? Keynes said the markets were propelled by animal spirits, which at times yield growth, but must be domesticated, right, by rule of law agreements, international law, norms, etc., so that the law of the jungle, eat or be eaten, does not apply. Okay, so investment agreements are in a sense an alternative, right? They promote and protect investments by allowing the rule of law among investors that come from very different systems, legal different norms, right? But they shouldn't undermine the rule of law. And so what do I mean by the rule of law? It's ironic that this non-lawyer, in fact, a dropout of law school, is lecturing to you on the rule of law, so please forgive me, but those elements are transparency, even-handedness, due process, accountability, predictability, and enforceability. Okay, but I would argue, at least through my research, which is right here, that international investment agreements and various bits do not consistently provide those norms all the time to all market actors. So that's basically what I need to say to you. And if you'd like to read it, there's a bunch of free copies. So why do I think that? Well, there are many types of investments that are not clearly defined consistently in all investment agreements. We all know investor state tribunals occur in different places. They have different sets of rules, so they yield different. They have different procedures, and they have different arbitrators making decisions on inconsistent language. There's no system of precedent, and so we've seen inconsistent decisions on the same issue using the same bit. Need I say the U.S. and Argentina? There's often uneven and toothless enforcement. Sometimes states ignore decisions, sometimes investors. We all know that investors at times cherry pick language from various bits. And why shouldn't they? That's the reasons they like bits. I would argue that despite the language on policy states, there's too many challenges on policy states, and investors challenge domestic laws as regulatory takings. Okay, then let's look at process of the rule of law. Is the process done in a way that meets good international law standards? So is it accessible to all? Is it administered fairly? Is it efficient, predictable, and certain? And I would argue, if you look at the record, we don't see that. And so for industrialized countries, right? So the United States, 28 countries of the EU are proposing including investment chapter in their trade agreement, right? TTIP. Seems to me that's a little strange. Don't they have good enough legal systems? Do they really need to rely on a system of arbitrators to decide investment agreements? What's wrong with the current judicial system? Okay, does it achieve these things I'm talking about? Okay, also, I think that including it in a trade agreement, I'm one of the few people on the left in the United States that actually supports multilateral trade liberalization, but I think the process is terrible. It appears undemocratic. It's often captured by special interests, and there's a perception that the process is not good for average people. So is that the right place to try to improve the rule of law? Not sure whether we're talking about TTIP or TPP, the other trade agreement that the United States is trying to As we all know, international investment agreements, whether BITs or investment chapters of trade agreements, have a legitimacy problem because they are inconsistent by design. They delineate investor rights and state obligations, but they rarely spell out investor responsibilities. And again, if you want some specific evidence of this, that's in that paper. So there are other ways to do this. I'm not saying abandon the current system, but I think we need to move towards greater coherence. I'm saying harmonize, because cross-border investment we need to stimulate cross-border investment and cross-border protection and promotion. So why not find another place internationally accepted? And so I would leave it out of TTIP, but I would also find ways to multilateralize the process, perhaps at the WTO. I don't have time to go through how we could do that, but I'd be pleased to do that in times of questions. So thanks for hearing me out.
Thanks very much, Susan. I expected to have to rigidly enforce the 10 minutes on everyone, but you're actually under time. So we'll give you some extra time in the responses. I now turn to Simon Lester, who's a trade policy analyst at the Cato Institute. And for any of you who work on particularly WTO issues, you'll know his website quite well, worldtradelaw.net, which is just a fantastic font of information about those issues. Simon is, I think, going to give us a slightly more skeptical view on the benefits of international investment agreements. So over to you, Simon.
Yes, I think that's fair to say. I think we're going sort of degrees of criticism here, with Ryan the strongest supporter, Susan offering some nuanced criticisms, and me saying throw the whole system out. To start, though, I think it really is difficult to talk about investor-state dispute settlement because there are so many issues going on at once, and everybody comes at it with their own perspective and ideology. It makes it hard to have a good discussion, but we'll do our best here to kind of focus on respond to each other and keep this a focused discussion. For me, all I can do is approach this from my own perspective, and so for me, one of the main things that investment treaty law, investor-state dispute settlement does is it takes familiar constitutional and administrative law principles from the domestic sphere and raises them to the international level. So, for example, Ben went through some of these. You have in the investment treaty context, you have something called fair and equitable treatment, and there are parallels in U.S. administrative law to that. And then you also have rules on expropriation and indirect expropriation. And then there are parallels in U.S. Constitution, the Fifth Amendment, the Takings Clause, and there are parallels to all of this in other countries' laws as well. So none of that really sounds too bad. We're just taking these familiar domestic legal protections and putting them at the international level. And I don't mean to overstate my criticism to all of this. There are things, if you're from the trade world, you'll be familiar with anti-dumping. That's something I really hate. I'm 100% against it. It has no redeeming value. Investor-state dispute settlement, I think, is a much closer call. My criticism of it is that I think proponents sell this as something that supports the rule of law. I'm not sure it really does that. I think having more law and more litigation is not necessarily a way to promote the rule of law in all cases. So what I want to do today is address two broad questions. The first one, is there really a problem with bad treatment of foreign investors? Because that's what this system is set up to address. There's this assumption out there that foreign investors are treated badly, and we need to do something about that, and these treaties are a way to do it. And then the second question is, well, if there is bad treatment of foreign investors, what should we do about it? So let's start off with, is there a problem? Is there anything to worry about here? So it seems to me that if there is a problem, it's a lot less than it used to be, for one thing. But let me look at two specific categories of alleged bad treatment. And we've heard a bit about these concepts from the earlier speakers. The first is expropriation. Is there this this vast expropriation of foreign investors going on out there? There's this economist in New Zealand who has studied this, and he has data through 2007, and my understanding is that he's updating it right now, basing my opinions on his data. And I'm happy to be corrected if somebody can come out with some different data on this. But based on what he's found, expropriation was a big problem in the 1960s and 70s, with 20, 30, 40 expropriations every year. Now it's down to about 3 or 4. Not that that's nothing, but it's just not clear to me that we need thousands of treaties to address it. Again, if new data comes out, if expropriations increase, I would be more convinced that there's a problem that needs to be addressed. But for what the data just doesn't support the efforts that are being undertaken. Now, let me talk about the more general obligations, like fair and equitable treatment. Is there any empirical data out there on whether foreign investors are treated unfairly or inequitably by host state governments? I'm not aware that anyone's really studied this problem. There's an assumption that foreign investors are treated badly in certain courts around the world or by certain legislatures. It seems to me we're basing our efforts in the investment treaty system mostly on anecdotal evidence. And it seems to me that we need to first determine whether there's a problem and what that problem is. Somebody needs to study the treatment of foreign investors in countries around the world to see what the actual problems are before we create this vast regime with a growing number of cases and litigation over hundreds of millions or billions of dollars to address it. So I think the problem hasn't been studied enough to merit the efforts that have been undertaken. In addition, there's all this concern about treatment that's bad treatment of foreign investors. It seems to me what I see, what I observe, what I read about is treatment of foreign investors that's too good. Now, anytime you read an article, in the newspapers about some big new foreign investment, say Mercedes in Alabama or BMW in South Carolina, inevitably what you see is, and here's the huge amount of subsidies they got to locate there. Just about every big foreign investment involves some subsidies. And it seems to me that's the big problem out there with foreign investment, is that governments are massively subsidizing it to no benefit. I mean, they're just shifting investment around. They're not creating new investment. They're just shifting investment around and subsidizing the foreign investors in the process. That's a fight worth having in the policy world. Let's go take on these big subsidies to foreign investors. It's the good treatment that really concerns me more than the bad treatment, at least based on the evidence that I've seen. Let me throw out another criticism, a sort of more conceptual criticism of it. 60 years ago, maybe, I think this whole issue made a lot more sense. When companies were mostly national in nature and would occasionally venture out and make a foreign investment, and that foreign investment seemed very foreign, and perhaps there was bad treatment by the host government. Today's world of globalized companies looks very different. So if you look at the auto industry, you have Ford and GM and Honda and Toyota, and they invest all over the world. They have factories all over the world. They're global corporations. Are they really foreign in any sense? If at this point, if Honda has a factory in Alabama, do the workers in Alabama think of themselves as foreign? I don't think they do. Chrysler is now owned by Fiat, an Italian company. So if the Transatlantic Trade and Investment Partnership comes into being, Fiat, the owner of Chrysler, I suppose could sue the U.S. government if Chrysler is badly treated, because Chrysler is somehow now a foreign investment. Conceptually, it doesn't make that much sense to me. It seems to reflect this kind of 1960s era idea of the structure of corporations. Okay, let me move to the second category of questions I'm raising. So if there is a problem, let's just assume there is. What, if anything, should we do about it? First point, which groups should get protection? Which individuals around the world should get protection? Who suffers abuses at the hands of national governments and could use international courts to step in? It seems to me, my top 3 choices here would be racial and ethnic minorities, women, religious minorities. I think those are a good top 3. There's probably others too. Now, how about big multinational corporations? I don't know. I'm not convinced. I'd put them around number 100. They've got the resources to fight bad treatment. So I'm just not that worried. If we're going to pick out one group to protect through effective international treaties, foreign investors would be pretty low on my list. Okay, another point about whether to protect foreign investors. Investing is risky. Why do we care about foreign investors' problems overseas? If you're Exxon and you invest in Venezuela, shouldn't you know that's risky? Aren't there actions you could take to address the risks? Get some insurance. Sign a contract with the host government that lets you go directly to arbitration. Why are we, and that could be the U.S. government or any government who's trying to protect its foreign investors, why are we spending all this political capital on treaties to protect these big multinational corporations who really could and should protect themselves? They took a risk. they should deal with the consequences. All right, but putting that aside, let's assume we are going to protect them. We've decided that we would like to protect foreign investors, and then more generally, these rights, these particular rights about expropriation and fair and equitable treatment, those are important rights, and we should protect them. So how should we go about doing that? What we're doing now is creating these international obligations and setting up these tribunals that, there's all kinds of, I think Susan's paper does a good job of kind of spelling out, the problems with the existing regime, and I don't think even the supporters think it's perfect. There's a lot of kind of tweaks you can make to make it better. But maybe there's a better way to promote these rights, and I don't know how many of you're familiar with the agreement, trade-related aspects of intellectual property as part of the WTO. What that treaty does is requires domestic governments to incorporate these principles into domestic law. It seems to me that might be a better solution here because, so for example, Canada's expropriation laws are not as protective as U.S. expropriation laws. So under the NAFTA investment chapter, what that means is American companies who invest in Canada get access to these rights, but Canadian companies don't. That doesn't make a lot of sense to me. If these rights are important, shouldn't we find a way to give them to everybody, including the domestic investors? Let me wrap it up there. I think we're just about at the 10 minutes. I'm going to stop there. We can discuss amongst ourselves and take questions.
Thanks very much, Simon. So, as promised, I'd like to give each of the panelists an opportunity to respond and add any points that they would like to add in light of the presentations that have followed them. Perhaps Ryan, given that you went first, it's first to come back to you.
Okay. Yeah, just a couple of points. One would just come from my experience. I worked in Central America for a couple of years for a law firm there called Arias y Munoz, and we handle a number of foreign investment controversies. And when you're on the ground in that kind of an environment, you do see that there can be problems in terms of lack of resources for the judicial system. There is higher incidence of corruption in those types of countries. Things are simply slower. There's a problem with bureaucratic intransigence. And so, these types of treaties exist so that investors can confidently invest, knowing that if there's a problem, they can have recourse to a neutral forum and have their claims heard. So, even where the incidence of the really dramatic expropriations might be going down, there's still a real need, I think, in places all over the world to provide these really basic kinds of protections for foreign investors just to assure that foreign investment continues. I think that perhaps the fact that there's been a sharp decline in the number of expropriations and bad treatment of investors might be evidence that the treaties are working as much as it might be an argument to get rid of the system. It's kind of like saying, I didn't need that test was so easy, I didn't need to study for it. I shouldn't have spent so much time studying. So there's that point. I also just wanted to also comment that the investor-state treaty regime kind of came about because prior to that, what would happen is investors who were having a problem in a foreign country would have to go to their home state government and ask, the executive branch of their home government to please go to bat for me and get involved at the state-to-state level regarding this very specific private dispute. That creates all kinds of problems to sort of throw a monkey wrench into larger diplomatic objectives between states. And so, one of the whole reasons, it's not to take these types of cases necessarily or solely out of national foreign courts. It's also to take it out of the international policy realm and just let these disputes be decided, kind of off to the side. So for those reasons, I think it's still very relevant and serves a very important purpose in a lot of places around the world.
Thanks, Ryan. Susan?
Okay, well, I don't mean to be argumentative, but I don't see the logic of that, and let me give you a couple of reasons why. The evidence just doesn't support that argument. At first, I thought, so let's look at it between the supply side of governance. Do investment agreements improve the rule of law, right, by government officials, whether they're judges or government officials? Okay, and the first thing is you would think they would, right, because courts realize there's some alternative that corporations might seek, and hence they might want to up their game. But there's no evidence that that's happening. And in fact, it seems like the opposite is happening, because when you create a special legal enclave for investors, those investors do not become demanders of good governance. And you want your citizens to speak directly, whether they're business citizens or individual citizens, speak directly to governments about what they need from government, right? That feedback loop that is supposedly democracy and the rule of law. And it seems to me what this does is, if you give investors as only a special class of investors, that special enclave, they don't become those demanders, and they don't interact as well with domestic corporations and spread those norms. So you're losing, I think, if you, sorry for the economist perspective, but you're not increasing the demand for good governance. You're bifurcating it, if you will. That can't be a good thing. A couple other things. I mentioned that not all investors or all types of investment are protected by an international investment agreement, whether a bid or an investment chapter. So, for example, lots of NGOs give land, Conservation International, their rights may not be protected under an investment agreement, but they are landholders. Again, it depends on the language. So either we find ways to make it accessible to all property rights holders, or we have to admit that the system is not consistent or fair all the time. Now, I think you could argue back to me, and you probably should, hey, the system is not always consistent or fair, and that's why we have different levels of court reviews, and that's a good thing, because there's a competition. But that competition is not occurring in many developing countries. So,
Well, unfortunately for Ryan, this is sort of an attack on him. It's 2-on-1 here. Apologies for that. So I'm going to just, picking up on something Susan just said. So the concern seems to be that there's some countries, maybe developing countries, have weak courts or are corrupt, and therefore it seems to me that what the proponents of ISDS are saying is we should outsource the judicial system there to an international tribunal. It seems to me it would be better for everybody, including domestic investors, if we could improve the domestic system. That's the ideal thing to do here. Now, maybe it's too hard. I don't know, but it seems to me that some efforts there would be useful. One of the other assumptions, I think Ryan alluded to this, is that this system helps promote foreign and direct investment. I think the studies on whether it does are mixed at best. It's not clear that this really has any impact on foreign investment one way or the other. And a country like Brazil, who gets lots of foreign investment, really never signs these treaties. And there's certainly a lot of investment in China from countries who don't have a bit with China. The issue of whether politically we should go, if we didn't have investor state, the government would have to go to bat for these companies. I think referred to as diplomatic espousal. If we didn't have this, the government would have to espouse the investors' claims. I don't think they would. I think they could just ignore the investors, ignore these demands from our companies. So, for example, Philip Morris. Philip Morris is being badly treated in Australia, maybe. I just don't know that I care. As an American, and I know Philip Morris isn't an American company, but let's just, it's kind of got different, nationalities. But let's just say Philip Morris is an American. So what? That's in Australia, and Australia has their court process, and I'm pretty confident in it. If you can show me there are some countries out there whose courts are particularly bad, then maybe we need to address those. I don't know, but just sort of the idea that we generally have to make sure that this investment system is available. I'm not convinced. There's the idea that having investor state similarly depoliticizes the process, because it makes those particular disputes less political. I think that may be true, but at the same time, it makes the trade negotiations that involve investment chapters, makes them much more politicized and controversial. And that's one of my big criticisms of all this, is that I can't get the free trade agreements passed because they've got all this other nonsense in it that's, and it frustrates me, because to me there's clear arguments for free trade and against protectionism. They're open and shut. We should do that. This one's getting in the way of all that. Last point. Did the emergence of the treaties lead to the decline in expropriation? I mean, certainly that's an excellent point if it's true. I'm not convinced that it is. I mean, I have to look more closely at this data. I don't know if it's the best data. Well, it is the best data out there because it's the only data. I don't know. Somebody else could look at it and maybe come to different conclusions. But from what I see, the expropriations declined before the treaties were really having much impact at all. Some treaties existed. There weren't really complaints under them. But I mean, it's something that this economist in New Zealand is kind of coming up with new data. Once he gets it done, I'll look carefully at it. And it is a valid point, if true, that the existence of the treaties undermine the expropriation. I don't think that there's a cause and effect there, though. But yeah.
Thanks very much, Simon, and thanks very much to each of our panelists. Before I bring us back to this question of individual and collective rights and how it interacts with the system and the comments that each of you have made, I should disclose with respect to the Philip Morris claims, I am advising the World Health Organization with respect to them. I won't pass any comment on them this evening, but I do have questions that no doubt relate to the subject matter of that. Now, question time. We need to start to conceptualize how this system interacts, for better or for worse, with individual and collective rights. And I think there are a number of different ways in which we can do that, two of them being, one, thinking about where investment treaties might be beneficial for individual and collective rights, such as by providing some protection against human rights abuses, for example. And recently we've heard mention of a claim by Al Jazeera against Egypt with respect to the closing of that office and alleged harassment by the Egyptian government as a potential example. So it's one sort of possible avenue through which investment treaties might theoretically promote human rights. But then on the other side of it, to think about where investment treaties might actually be problematic for human rights or collective rights, economic, social, and cultural rights being potentially examples. And Ryan, you've raised the example of tobacco control and regulation by governments, and no doubt there are others that relate to, say, protection of public health, such as privatization of water, provision of other public goods by foreign investors, and we can use them as sort of case studies in our discussion. And I want to try as much as possible in these questions that I ask each of you to keep us thinking about that connection with rights, individual and collective. And Ryan, I'll come to you first since you spoke first. And I do promise, and hold me to it, that I'll give you an opportunity at the very end to give a final comment so that not everyone else has the final word. The Philip Morris claims, as you said, they've raised a lot of political controversy about the value of investment treaty arbitration and its merits. And I want to ask a question, one question about the forum for settlement of that dispute. And you mentioned that it provides a neutral forum outside of the domestic courts. And I want to ask you whether or not you think that is the most appropriate forum for resolving regulatory disputes of that type of character. First of all, it being at the international rather than at the domestic level, and second of all, it being done through arbitration rather than by people who are judicially appointed by a democratically elected government. So I guess that's the first question, whether it truly is the appropriate forum to be deciding questions that might bear upon economic, social, and cultural rights.
Okay. Well, we have to be clear about what the question is. If the question is an investment tribunal the appropriate place to make decisions about claims about human rights or claims about health, deciding national policy about the environment, that is probably, the answer to that is probably no. The investment arbitration is there to decide questions about investment, and then in some cases, those questions start to touch on and bump up against national policies in those areas. And so, and as I was covering in my presentation, there are a number of principles, guideposts that kind of help the tribunal know when they're bumping up against that territory and when they need to give deference and give way. They typically are loath to go into the merits of particular policies to dictate, well, you know, Australia should have done it this way. The better way was to tax the cigarettes, not prohibit the advertising. They're not really going to go into that area. And so for these questions, which are centrally about investment rights, they are a very specialized court and expert in answering those types of questions. So I do think that is a good use of it.
I guess then one follow-up question might be, what would you say to the critics, including Susan, who've suggested that when we look at investment arbitration, we see tribunals going one way on an issue and another way on an issue. We don't have a doctrine of precedent. We don't see consistency and predictability in the reasoning of arbitral tribunals, let alone in the decisions that they make, sometimes arising out of very similar or the same fact patterns. How is it that we can then rely upon your argument and sort of trust me, the tribunals don't overstep their mark in that context?
This area of the law that we're talking about is effectively, in many ways, like the Wild West, and that's why it's a really fun place to practice. The increasing flows of investment and transactions around the planet, especially in the last, say, 4 decades, have spurred the proliferation of thousands of bilateral investment treaties. Why is this happening? It's because there is increasing occasion for the rights of individuals who are investors and the sovereign rights of states are increasingly coming into contact with one another. And so the system as it is right now, you have to understand it as a work in progress. It's reacting to this phenomenon that's happening in the world. We are used to, in Australia and in the United States, a common law system where case law is binding and therefore judicial decisions have to sort of follow one another. But in many other countries around the world, for example, those that are in the civil law system, code is binding and judicial decisions are merely persuasive. And so in that area and in many areas, investment arbitration tries to have respect for both systems and split the difference. And there are other examples as well. And so I think that the criticisms are, I think, most useful to help the investment treaty regime advance to where it needs to be rather than tear it down. I mean, these are useful, constructive criticisms to say, where do we go next with this? What's still missing? That's kind of how I interpret it, just as a work in progress. And so, you know, if it takes 6 months to build a house and in 3 months you say, well, you know, this part still isn't built yet, that's not a reason to just tear it down. It's like, yeah, let's keep going. That's where we need to work next.
Okay. So without, I guess, prejudging that question of whether to tear down the system or build it up, Susan, I want to come to some of the comments you made about how to improve the system. And in particular, you mentioned multilateralizing it. And in that respect, I have 2 questions. The first is, in a system where legal protection is based on nationality, the international investment law, is it ever truly possible to have anything other than a universal system that would in fact comply with your requirements for rule of law? Because isn't it, by its very nature, as a spaghetti bowl, discriminatory? Okay, so that's an easy answer.
But I think if I may go back to Ryan's question, because could I just add, could we just turn down the air conditioning because it's really blowing. Thank you. I'm sorry to be. I hope I don't discomfort other people, but many of you have studied human rights law, and you know that there is no binding system of enforcement, whereas here in the international investment system, there is a system of enforcement at the bilateral level, right, and possibly at the regional level. And so I'm not saying that the best system has to be harmonized, multilateralized. But I think, as Ryan aptly pointed out, the human rights system is coming into direct and indirect conflict with the investment system. And we have not figured out ways to ensure that human rights, specific human rights, whether they're intellectual property rights, which are a property right, which are a human right, or access to health, safe drinking water, etc. So looking at the direct effects or the indirect effects of the international investment system that we've chosen on specific human rights. Interestingly, I've been working for the past 4 years looking empirically at data on trade and human rights. So we look at specific human rights and the effects of trade agreements or trade. So it's important what you look at on a specific human right. And that's been very interesting to see. I've never seen anyone do any empirical work looking at investment agreements, because each investment agreement is different. They're not the same as various FTAs or the WTO. So we really don't know these effects. But until we do know these effects, we probably shouldn't generalize. But again, to come full circle, I do think a large part of the problem is there's no means to encourage governments to meet their human rights obligations, whether at the national level through their constitutions or at the international level through international law. And so these conflicts are going to keep coming up. And unfortunately, I see a lot of demagoguery in people's various positions. On this issue, it's either yay or nay. I agree with Ryan that we have to find some way to protect investment. I am totally convinced by Simon's argument that this system is totally out of date in the world where corporations are multinational, often, regional, often, have no incentives to protect human rights, often bigger than governments, and why should they have special rights that are established in international law? It's a puzzlement to me.
Okay, thanks, Susan. And I guess the next aspect of my question, which comes to comments each you and Simon have made, concerns somehow multilateralizing this system. And I'm going to put it bluntly, ask you whether that is in fact some form of imperialism through international law, and whether in fact we can really hope for an international system where we have universal recognition of exactly the same degree of property rights protection in each country, rather than a diversity of approaches or plurality of approaches. And intellectual property rights seems like a perfect example of that. We look at the international level, we look at the TRIPS agreement, and we see there are flexibilities that each WTO member, for example, implements it in accordance with its own domestic system and priorities. So perhaps Simon and then Susan, you might want to comment on that.
Yeah, just a couple comments. First, as a general matter, I prefer multilateral to bilateral. It's much better in terms of economic efficiency. So if there's a choice between those two, I'll always go with the multilateral. It can't always be achieved, and I guess that's why we're in the state we are. We can't do much with it in the trade regime either. In terms of sort of the imperialism element, I think then we get into the substance of what should these agreements say. For me, a non-discrimination obligation, and that's part of these investment treaties as well. That's a good thing to have. In general, we don't want to discriminate against each other. There are economic benefits, there are international relations benefits, and so if that's all the investment treaty regime did, I wouldn't be that concerned. I think that's a great part of the trade regime. Having that part of the investment regime doesn't really bother me. Then we get into the property rights issues, intellectual property, and there, I made reference to the TRIPS agreement earlier as a model. I've got plenty of criticisms on the substance of the TRIPS agreement, and there I think. Sort of procedurally, I like the way the TRIPS agreement works, but in terms of the substance, no, there's a lot I don't like about it, and I do think we should allow for a diversity of views on property rights, intellectual property rights, human rights in general. It's a difficult line to draw. I'm not a human rights expert, but I think we have to, we have to acknowledge that maybe there are a few universal principles out there, but there are a lot of principles where there's room for disagreement, and intellectual property and property rights and the sort of due process standard, I think that's one where we should give some flexibility.
And Susan, just
you said due process standard. You want some flexibility?
I mean, I'm not a due process expert, but I think that there's not. I don't know the universal due process standard that we could say everyone has to do this. I mean, maybe we could set some general framework and say within that, you can do this, but I don't know the topic well enough to really say here's where I would allow you to do this but not this. I don't know the answer, but I'm just guessing that there's probably some. We don't all do it the same way,
Right.
And that's probably fine in many cases. I'm guessing Australia does a little differently, and I'm guessing I'd be fine with what Australia does. So.
Might even be better. Who
Might
knows?
even be better.
Susan, final sort of question and comment on this idea of multilateralizing the system.
I just don't see it happening, partly because policymakers have tried 5 times to come up with an international investment agreement. I wrote my dissertation on the first attempt and the ITO, and they could never find common ground on the rights and responsibilities of investors or states. And so, and that, in the end, is the dilemma. But I come back to Simon's point, and I wonder in this day and age when we laud Starbucks for a commitment to educating its workers, and then we scream at Starbucks for having all sorts of tax scams for not fully repatriating from, let's say, Great Britain to Ireland to the United States, whatever. Does this seem logical to give these companies special courts to where, within investment agreements? Because the way the United States trade policy process works is we like to, once it's in one agreement, we like to tap it to the next agreement and add on to it in the next agreement. We rarely drop it. But I think it is interesting that powerful countries like Britain, I misspoke, Brazil, South Africa, India is moving in this direction, are saying we don't want to have investment treaties. We are all smart people, and I just wonder, is there some other way that we can find to protect investment, to delineate the rights of investors, but improve the local court's ability to mediate investment disputes? Seems to me that that's the question.
And of course, multilateralizing the system would in effect be accepting this underlying assumption that it's a good thing.
Yeah.
Which is something we haven't really got into this evening. But before I throw to the audience, Ryan, any observations or comments you'd like to add?
Yeah, just a couple quick comments. I am attracted to the idea of multilateral. It'd be kind of neat if there was like just a convention that was sort of a standard bit, and everybody kind of agreed on the terms and signed up for it. There may be an argument though to have bilateral agreements. Each pairing of states may want to calibrate based on the desired outcomes that they want. For example, the United States is a big proponent of this minimum standard of treatment under customary international law as the standard for fair and equitable treatment. So unless the United States did something really horrible and egregious to the foreign investor, basically the foreign investor's recourse is in the courts of the United States, right? So in a place where we have a robust legal system, that might be the tack to take. But in a country whose legal system isn't very strong, they don't have a strong court system, if they, as a policy matter, want to attract a lot of investment, they can opt for sort of a higher standard of protection, which is known as the independent treaty standard, right? So it might offer a little bit broader protections in a way, in a case-by-case basis for countries to, achieve certain outcomes with certain other partners. And then I just also wanted to say too that it is a little troublesome taking these controversies out of national courts, right, in a way to arbitral tribunals, and what does that do for the rule of law in those host states? There's the OAS right now is working on a project to educate judges in Latin America about arbitration rules and enforcement of awards. And the whole idea is that you can't really have arbitration or a judicial system working effectively unless both of them are strong. So it's sort of a call to reinforce both of those avenues of justice. So I think that's kind of interesting. And then lastly, also thinking about rule of law, on the issue of political risk insurance, it does happen in countries. I'll give an example of Bolivia, where during a certain period of time, the government enacts investment laws, signs up for ICSID, enters into all these bilateral investment treaties, and writes all this investment. Then they decide they want to change legal regimes, write a new constitution, withdraw from ICSID, cancel their investment laws, and nationalize all those investments. And so who bears the cost of that? If the cost is on the investor and his insurance company, and you remove that cost from the state, there's not so much incentive for the state to perhaps choose a little bit more moderate political course, which arguably could be better for a lot of folks. So it's just a question of where do you want that cost to fall, and what's the outcome on stability in those places. So just something to think about.
Can I respond to that last point?
Yeah. I'm sorry, you cannot. You may get a chance with the audience questions or comments, but we do absolutely have
rules,
to throw the audience out.
Right.
I'm well behind time, and I can see Emily looking at me. So questions, comments from the audience, and please just identify yourselves before posing your question or comment.
I can kick us off.
Excellent.
So I was just interested because we heard a lot about sort of inconsistency, problems of precedent, and the desire to have a neutral system. And one thing we haven't heard about that I was wondering if we are concerned about, or maybe we're not concerned about, is this question of independence, and whether arbitrators and sort of arbitration lawyers more generally can ever really attain the standards of independence that we expect of tribunals that are making decisions in this kind of area, given that they really are stakeholders in the system, in that their interests lie in perpetuating investment system, because that's what generates arbitrations that generate the work. So is that something we're concerned about, or perhaps it's not something we're concerned about? I'd just be interested to hear your views on that.
I should say as well, if you have a question for a specific panelist, then please identify the panelist. Otherwise, you can frame it to the panel as a whole. Simon, you had a burning comment.
Yeah, no, I'll just say on that one, it's definitely a big concern, and I'm not an expert on this, but I've read what people have said about it, and I think it really undermines the credibility of the system to have people, one day arguing a case and the next day being a judge on another case that maybe has an impact on the case they're arguing. I do think that the proponents of the system, if they want to give it more credibility, should look into problematic aspects like this and try to fix them, because I think that's where most of the criticism comes. And the criticism seems very strong and could bring down the whole system. Now, I kind of have a different take on it, and I want to question sort of the underlying basis of the system. But yes, these particular aspects make it look bad, and I think just open it up to criticism. And I'd be curious to hear Ryan's take on it, though.
Okay, well, yeah, certainly this is a big issue, especially because of the figure of party-appointed arbitrators. So it's possible for each party to select any arbitrator they want, as long as the arbitrator is not of their own nationality or of the other party. So you can have repeat appointments and repeat players, and in arbitration in general, it's sort of a specialized field, right? So you have specialization in investment law or specialization in reinsurance or some area of commercial law or something. So it tends to be a smaller pool. There is a little bit of a problem there because, for example, in U.S. courts, in the Seventh Circuit, Judge Easterbrook had to evaluate a claim to annul an award, and on grounds that there's impermissible bias on the part of the arbitrators. And he looked at the matter, and these were party-appointed arbitrators. And he said, well, if it's a party-appointed arbitrator, obviously that arbitrator is an advocate for the party that appointed the person. And if that's what the party's contracted for, they can't complain now that the arbitrators are biased. If you kind of take that attitude over to, or that line of reasoning over to ICSID, ICSID requires in one rule, it requires arbitrators who are not biased, but then the default rule is party-appointed arbitrators. So it just sort of sets where you're kind of going, And right now, there's a pretty active debate going on about how to resolve that tension and ensure appearance of non-bias and legitimacy, while at the same time respecting parties' contractual right to have their own party-appointed arbitrators. I'm not sure what the solution is, but that is the debate.
Other questions? Down the back here, then.
That I think there is generally a legitimate problem with the system, and I think that's one of the problem between investor-state settlement system and the defense of human rights, individual rights, collective rights. However, I think that the panelists that are on the extremes have perhaps not taken into consideration what were the origins of the system. I mean, the system was not created with this grandiose idea of promoting the rule of law. It was something a lot more specific. I believe that the development of the investor-state settlement system goes hand in hand with the development of ICSID. It was created with the simple idea of promoting the flow of capital investments from private investors to countries that wanted to hold those investors. As Dr. Susan said, they tried to get into a multilateral agreement and agree on substantive protections. They couldn't do it, and so the World Bank said, what can we do? We need private investors to go more into developing countries. What is the next thing that we can do? Maybe if we set up a neutral forum where investors can feel more comfortable going to the courts, that will help them go and put their investors there. So that was the whole purpose of the system. The system was not thought as something that would go hand in hand with treaties. The system was created with the idea of an investor signing a contract with the state, including an exit clause, and thereby being able to go to arbitration. It was until the 1990s that a tribunal decided, hey, there is indeed a treaty where a state said, I'll give you the offer to go to arbitration, and then the investor could accept that offer in some way. They decided that the investor could do it afterwards by presenting a claim. That was the purpose of the system. It was not to do this wonderful thing of advancing the rule of law. It was to promote economic development. Whether indeed it has done so, that is a different discussion. But from what I understood from those presentations, the basis was the principle, the idea of the system is to promote the rule of law, and it hasn't done so.
No, hold on. We're saying apples and rocks here. The research question is, do investment agreements, right, the whole agreement, do they advance the rule of law? Not does investment or state arbitration under a particular investment agreement. Right?
But the question was if the investor-state dispute settlement mechanism, not the agreement itself. And I think indeed it's a different question whether at that point it makes sense to create it and whether you should continue incorporating them now in the agreement. That I believe is a different question. But to say that there are 4 expropriations today in the world is a little US-centric. I mean, we have basically presidents going out on TV saying, I'm expropriating this. Whether it's illegal or legal is a different question, but expropriations do happen. And so I think the idea of what what the system was created for is one thing, and it has come to a place where it is, in fact, clashing with individual rights and human rights. And what is it that we can do in order to protect those human rights through the system that is there, as Ryan was saying? I think it's the most important question.
But if I could respond, I mean, I feel like, and I don't think you were intending to, I feel like you're making my point for me, because what I argued and what I wrote is there was a big problem in the 1950s, 60s, and 70s with the treatment of foreign investment. That problem has largely gone away and turned to one where governments are desperately trying to attract foreign investment by giving foreign investors subsidies. That's not to say there's no bad treatment, but it's a very different world we live in today. And I think the existing regime is based on actions that happened in the 50s, 60s, and 70s. We don't really know what's happening today. No one's really studied that. With expropriation, it's, as I said, it seems like it's gone down tremendously. With this other sort of vague, unfair, and inequitable treatment, I mean, no one's really studied it. I don't know. What are the problem countries? Who are we worried about? Going back to a point about the U.S., and I know people say the U.S. has never lost a case. I don't think the U.S. is invulnerable here. There's a case going on against the Canadian courts right now related to a patent decision. I can easily imagine a U.S. Supreme Court decision that changes the landscape on, say, software patents or gene patents that affects foreign investors negatively, and somebody sues the U.S. government based on a U.S. Supreme Court decision in one of these international tribunals. So I definitely don't think I'm being U.S.-centric on this, and I'm not letting the U.S. off the hook. I just want some actual evidence of what the problems are in different countries around the world, because I don't think the problems are very similar to what was happening at the time the regime was created. I think it's a very different world today.
I dare say before we come to the next question, there's perhaps some merit also in distinguishing between nationalizations on the one hand and expropriation on the other. And certainly we can see this historical trend away from nationalization with some notable exceptions, particularly in South America. There's a question.
Yes. Sorry, can we use this just for live streaming purposes? It might be easier for them to hear. Thank you.
Will do. Ms. Aronson, Mr. Lester, you will forgive my fool's breadth of knowledge of the subject, but I'm really baffled by how we're talking about transparency and rule of law and human rights in connection with arbitration agreements. If the issue is public health and transparency in creating a feedback loop where the government is responsive to the needs of corporations or to their own citizens, aren't we penalizing corporations by destroying these agreements for a failure of the government to take adequate protection measures, whether that be, as someone mentioned earlier, taxation? I think it was Ben, you brought up that example, or something else. By forcing corporations to turn to corrupt or underdeveloped judicial systems, I'm just thinking of Dole Banana in Central America that was using a toxin that caused terrible kidney failure in most of its workers. So what Dole did was paid off the courts because it could. I think that there's a real potential for these investment agreements to have provisions on them which make corporations accountable directly to the government for specified objectives, whether that be public health or protection of water or whatever else, in a way that the judiciary, because it's so supposedly insulated, isn't responsive to. And that idea of creating dialogue between corporations, citizens, etc., and enforcing human rights is totally separate from what goes on in that investment agreement. I would just like your input on that, because it's not really hitting me how you're connecting all of this.
It sounds to me, if I understood this correctly, it sounds to me like you want these agreements to be used to promote human rights. You can certainly make that argument. I have friends who make it, but I think there's a reason that they're not, which is that corporations don't want them to. Now, maybe you can, get your lobbying efforts together and bring human rights into these agreements, and they can be used for what you're hoping for. I think that's going to be a tough battle, but that's not how they're used, and I don't really anticipate them being used that way. I mean, I don't see proposals by governments to use them that way. So, I mean, it's a fight worth fighting for those who believe in this. I would not expect too much success there, but I don't know. I mean, I think Susan has thought a lot more about this than I do. Maybe you agree. Maybe you have a way to get this done.
First of all, I could really feel the passion in your voice, so thank you for your comments. I probably didn't do a good enough job of explaining my comments, so I hope you'll take the time to read it. But in 2 minutes, basically, again, I believe investment needs to be protected. I also believe very strongly that we need to find incentives to encourage both citizens to demand their rights and governments to provide the rights. Okay? I don't think, frankly, investment agreements are the place to do that, and I don't think at the bilateral level the system is working. So I came here to talk about my research, which looks at the rule of law and investment agreements and tries to get people involved in the investment debate to think a little bit about why the system is not working as well as it might and what we might do in the real world to move it forward. I wasn't trying to address the question of human rights, but I have, I mean, this is something we can talk about longer. I've now been a human rights advisor to 2 major corporations, Ford Motor and Levi Strauss. I'm no longer an advisor to either of them. And I can tell you that and Levi Strauss is probably one of the most devoted to human rights multinationals there is out there. But there is no board responsibility for human rights. It is not an issue that the shareholders care one iota about. Or maybe they do invest in Levi Strauss as opposed to Yves Saint Laurent or something else because they think it's a little bit more human rights oriented. But it just isn't the mode of corporation. And so I would say this is not the best strategy by which you want to advance human rights, if that is your objective. But again, my objective in presenting my research was to talk about what do we know regarding the international investment system over time, what has been its effect on the rule of law. And so if you want to continue to have that dialogue, I'd love to hear your thoughts after you read the research.
Okay, well, I'm conscious of the time, and I'm getting the signal that I need to wrap it up. So if there are final questions or comments, then I'd encourage each of you to approach our panelists in the, I guess it's not the dining room, is it? But the foyer. Refreshments have been served, I believe. But I just want to say, I think that last question really brings us back to this question about the foreign investor potentially as the rights violator and the one-way nature of this system, which is one of the ways that we posited that the system interacts with human rights. The other, of course, being the foreign investor as potential claimant of some violation of its human rights, and specifically its property rights, but also potentially other rights. I want to thank the American Society of International Law. I want to thank Emily McKenzie for putting together what I think has been a great panel, and each of our panelists, and hope to see all of you next door for refreshments. Thanks again.
Back and forth, I thought, I mean, I feel like the presentation is always just, kind of separate, but I think it really came together and we had some good interactions.
I really enjoyed that. Thanks, John.
Thanks a lot. You did a really good job.